And now I'd like to introduce our distinguished speakers. Complete biographies are included with today's PowerPoint. Kelly Highland Heinrich is co-founder of the Global Freedom Center, a nonprofit social entrepreneurship training thousands of government, nonprofit, and private sector professionals to identify and prevent human trafficking. Kelly advises Fortune 500 corporations on practices and policies that prevent human trafficking, impacting global supply chains and workers worldwide. E. Christopher Johnson, Jr. served as General Motors North America Vice President and General Counsel until his retirement in 2008. Following his retirement from GM, Chris joined the faculty at Thompson Cooley Law School, where he served as a law professor and director and founder of the LLM program in corporate law and finance. He recently co-founded the Center for Justice, Rights, and Dignity, a nonprofit entity to address trafficking and supply chain issues. Martina Vandenberg is founder and president of the Human Trafficking Pro Bono Legal Center. She established the HT Pro Bono in 2012 as a fellow at the Open Society Foundations. Prior to becoming an OSF fellow, Martina served as a partner at Jenner & Block, where she focused on complex commercial litigation and internal investigations under the Foreign Corrupt Practices Act. Mia Winkley has been a special agent with the U.S. Federal Bureau of Investigation since 1991 and has successfully investigated criminal matters related to violent crimes, crimes against children, white-collar crimes, public and police corruption, hate crimes, civil rights, and human trafficking. Mia has served as a supervisory special agent in the Office of Equal Employment Opportunity Affairs, the Office of Congressional Affairs, and the Training Division.
And now I will turn it over to our first speaker, Kelly. Thank you.
Hello, everyone, and thanks for joining us today. Let's begin. The legal definitions of trafficking vary, depending on whether you're prosecuting a trafficker federally or at the state level, seeking immigration relief or public benefits for victims, drafting corporate policies to prevent trafficking in the supply chain and procurement, or if you're seeking civil damages for victims. We have a wide audience joining us today, so rather than provide all of those definitions, this is a good working definition. At its heart, trafficking is about exploitation. It's the use of force, fraud, or coercion to compel someone to work or perform a commercial sex act. Now, the few reliable statistics that we have about trafficking are all simply dreadful. Estimates range from 21 to 30 million people worldwide. Given all the media attention that focuses on sex trafficking, few people realize that actually 78% of the problem is in labor trafficking and 22% is sex trafficking. Women and girls are the vast majority of sex trafficking victims, though men and boys can be and are sex trafficking victims too. On the labor side, women comprise 44% of labor trafficking and men 56%. Now, when you break it down, there are three primary places you find trafficking. First is the extraction and harvesting of raw materials like gold or coffee, wheat, cotton. The second is in the manufacturing of those goods into products. So the shoes on your feet or the computer in front of you bringing you this webinar. What you see here on your screen is from the U.S. Department of Labor. It's a list of 134 goods known to be made by forced labor or child labor, and they're in 74 different countries. The third place we find trafficking is within services. Here in the U.S., we've seen cases in nursing home facilities, restaurants, construction, strip clubs, janitorial and landscaping services for businesses, homes with nannies and domestic workers, moving services, and the list just goes on and on. This is in addition to sex trafficking occurring in street prostitution, brothels, and massage parlors. So as you can see, trafficking is in the products that we purchase, and it's also in the services around us in our communities. Now, let me just give you a few examples sort of ripped from the headlines. We're all focused on the current World Cup matches, go USA, but the 2022 World Cup in Qatar is getting a lot of attention as well. 94% of the population is already made up of migrant laborers, and it's estimated that an additional 1 million are needed for the massive construction and infrastructure projects. Human Rights Watch has been closely following and monitoring any abuses, including claims of trafficking that are really linked to excessive recruitment fees that in turn lead to crippling indebtedness for the workers. Plus, there's a restrictive immigration program that makes leaving an employer incredibly difficult. Also all over the news is trafficking in the Thai fishing and shrimp industry. The reports are of men held on fishing vessels for years, working 30 straight hours with physical and mental abuse, no pay, threats to harm their family members, and even threats of crushing debt if they leave. The shrimp processing factories really are no better from the reports that are coming out. It's primarily Burmese migrants that are trapped there with their identity documents confiscated, physical and sexual abuse, and debt bondage. Consider that the U.S. imports 1/3 of its shrimp from Thailand alone. Coming out in the news also, Walmart, Carrefour, Costco, Whole Foods have all come forward announcing that they're undertaking reforms of some sort, dropping certain suppliers, increasing their audits, and working with NGOs that help workers report abuses. So there are many layers that make up the current anti-trafficking landscape, which has brought you here to this webinar today, and is also driving corporations and their counsel to take notice. First, there's simply the nature of business today, where supply chains are extended, truly just massive. So take, for example, Apple's 200+ suppliers that are in every corner of the globe. Nike has more than 900 suppliers worldwide. And Walmart really tops the charts with an estimate of about 60,000 suppliers. So the logistics, needless to say, are complex. Migration for work is at an all-time high also, in part to meet the incredible demand. And this has also given rise to unregulated and often unscrupulous labor brokers who charge enormous fees and defraud workers, setting up conditions that are really just ripe for trafficking the moment a migrant worker arrives at a factory, for example. Next, there's the rise of other fields really within business. There's corporate social responsibility, which really took root primarily around the environmental movement, but now has grown to encompass labor practices. Ethical sourcing is another voluntary effort with the goal of minimizing the company's impact at the source of the product. And that work cuts across the environment, communities, and laborers. Starbucks, for instance, has pledged to ethically source about, well, right now it's at about 92%, I think, but they have pledged by 2015 to have 100% ethically sourced coffee beans. Business and human rights is also getting a lot of attention, with more and more companies undertaking commitments in line with the UN guiding principles on business and human rights, which really require impact assessments, ongoing policy development, and risk mitigation. So anti-trafficking, as a component of all these broader efforts, will continue to benefit as those emerging fields gain more traction. Another part of the landscape is simply the level of broad general awareness now about trafficking. Years ago, no one had even heard of trafficking. Today, we've got trafficking subplots on TV shows and more media attention than ever before. It's really become a leading human rights issue, and it's both outraged and inspired many to activism. Then there's more research than ever before. I mentioned the Department of Labor's list of goods available by good or by country. The State Department's Trafficking in Persons report has a description of trafficking in every country and an assessment of the government's response to it. There are other research reports into the fishing industry, palm oil, cocoa, labor brokers. The list goes on and is growing. So there's more access to information that's putting companies on notice and helps to inform risk assessments and target any risk mitigation efforts. Yet another layer of our delicious cake here is the growing number of NGOs whose sole purpose is really to aid consumers, to have them vote with their wallets according to corporate anti-trafficking policies. In one app, you can scan a barcode while you're in a store and get a letter grade for that company, as well as the grades for the comparison products, and then make your decision accordingly. Finally, in an area, I suppose, dominated by voluntary codes of conduct and initiatives, our icing on the cake here is that the government's stepping in. And I'll give you two examples. First, there's a proposed federal acquisition regulation, or the FAR, on trafficking that requires zero tolerance by federal contractors. And it prohibits them from engaging in quite specific behavior, such as confiscating passports, charging recruitment fees, or misleading workers during recruitment. Any overseas contracts in excess of $500,000 requires a compliance plan that's publicly available. Next, the California Transparency and Supply Chains Act, or SB 657 as it's known, requires a public disclosure for retailers and manufacturers with revenue over $100 million annually worldwide, stating the extent to which the company verifies its supply chain, conducts supplier audits, requires supplier certification, has internal policy and standards, and delivers human trafficking training to employees. Now, the landscape as I've just presented it poses a series of risks to corporations. High-profile labor incidents carry the same risks to operations as do natural disasters or extreme weather or cybercrime. Imagine the discovery of forced labor at a supplier factory that's of sufficient scale it hits mainstream media. In many cases, the only appropriate response, as we've seen with the example of the fishing industry in the news right now, is to terminate the supplier's contract. But what's the impact of that supply chain disruption? How dependent are operations on that one factory? How quickly can you bring another factory into the network or ramp them up to meet the demand? So in this case, lost time really equals lost sales and profit. Forced labor claims and noncompliance with, for example, the FAR I was just mentioning, can result in contract termination and debarment from federal contracts. There's civil litigation concerns, the Alien Tort Claims Act, Fair Labor Standards Act, numerous contracts and tort claims. And this is what Martina will be sharing with us in a few minutes. As well as criminal or civil litigation or administrative actions under the Foreign Corrupt Practices Act, where trafficking is closely linked to corruption and often facilitated by government officials. Criminal enforcement, my FBI colleague will detail, and of course, any of these things will impact the company's reputation. Consumers impart responsibility to the brand when something goes wrong, and we've seen this in numerous cases, regardless of whether the brand supplier was first, second, or third tier in the supply chain. So, you know, whether it's a smartphone app, grading a company with an F, lawsuits over labor conditions, or headlines of, quote, slave labor found in a company's factories, the resulting reputational harm damages the bottom line. At the Global Freedom Center, we've had two kinds of clients. One kind comes to us to strengthen their policies and roll out training, understanding the risks and value of risk mitigation. The other kind has had an incident occur, either quietly or flashed about in the media. But then they also have to go back and essentially undertake those same steps of strengthening their policies and rolling out training. But they've got the fallout from the incident, obviously, and they've got the additional expense of damage control to move through. Either way, anti-trafficking is a matter of integration. It's weaving it into existing policies, assessments, and initiatives. Thanks for your attention. I look forward to your questions at the end. And now I'll turn it over to my colleague, Special Agent Neil Winkley.
Thank you, Kelly, and good afternoon and good morning, everybody. Let me start with addressing the fact that the FBI recognizes that human trafficking is a crime that strikes at the very heart of American promise, which is freedom. The FBI, as well as the Department of Justice, and its partners are working hard to identify and support victims and bring their abusers to justice. And I thought it would be helpful to talk a little bit about the methodology of how we approach these investigations. We generally use an enterprise theory of investigation. So this is our methodology, the standard investigative model of the FBI that we employ in these cases. It requires us to focus on intelligence and seek to discover the full scope of the criminal organization as it relates to members' activities, and particularly when it comes to forced labor or involuntary servitude. It is important to understand the full scope of who may be involved in these crimes. We generally have a long-term focus on these cases, and I'm catching up with my PowerPoint here. And these cases do require us to identify and have a predicated crime regarding the organization. Our goals are to look at the existence and the structure of the organization and identify the individuals who are commanding and controlling the organization as well. One of the purposes for doing this is to seize the economic resources of the enterprise, either through forfeiture or through restitution for victims. The issues with these cases, as we go with this enterprise theory that come up, are the fact that they are manpower-intensive. Resources are needed, and a lot of resources are dedicated with manpower and squads and task forces, and I'll get into a little bit more about that later. But we do employ sophisticated investigative techniques, and I think that those techniques, while I can't get into specifics because they're method, means, and sources, suffice it to say that they are advanced and they are used to obtain the best information and evidence possible regarding a case. With respect to international trafficking of persons, the FBI investigates the trafficking involving foreign nationals, which is often aimed at recent immigrants or other economically disadvantaged individuals, and in particular women and children. Obviously, these are people who are preyed upon for their vulnerabilities and seeking a better life. The traffickers force migrant people to work without proper documentation or work in precarious situations that are poor standards, unsafe conditions, where they are exploited for prostitution, domestic servitude, migrant farm labor, or toil in restaurants and service industry jobs. Compounding this problem is the number of migrants subjected to these types of crimes is underreported, as many fear deportation or are afraid of retaliation against their families or individuals in their home countries should they cooperate with law enforcement. The FBI, together with our law enforcement partners in the Department of Homeland Security, as well as the Department of Labor and the State Department's Diplomatic Service, are working hard to combat trafficking in any form, not just because of the physical or psychological tolls it takes on individuals and their families, but also the profit generated by this exploitation that fuels further unlawful mitigation and organized criminal activity. with respect to, I'm trying to catch up on my slide here, if you just give me a moment. Well, I'll just go on and suffice it to say that today the FBI participates in over 100 human trafficking task forces and working groups around the world. We work shoulder to shoulder with many organizations and individuals to combat the exploitation of individuals who work in the industry, such as agriculture, domestic service, and those who are forced into prostitution or slave labor. Many of our offices produce threat assessments to determine the nature and extent of the human trafficking problem within an area of jurisdiction. We have certain offices that particularly focus on this in major cities. And basically what they're tasked to do is to aggressively pursue human trafficking investigations and develop actionable intelligence. The information obtained through these threat assessments can further aid us as we go about looking for potential cases and help us better understand the nature and scope of what the problem is within a specific area of responsibility. One initiative that the FBI does have is the National Hispanic Sex Trafficking Initiative, and this initiative essentially is a unilateral agreement between the United States and Mexico where we work as partners to bring high-impact prosecutions both under United States and Mexican law to more effectively dismantle human trafficking networks operating across the U.S.-Mexico border. The goal is to prosecute human traffickers, rescue human trafficking victims, and reunite victims with their families in these cases. Moving forward with this, the FBI's Civil Rights Program, which is run out of the Department of Justice, basically, go to the previous slide. I'm having issues with this, I apologize. These are the statistics that we have as recent as 2002. So our pending human trafficking investigations has increased significantly since 2009. In 2009, it was 167 pending cases, and as of fiscal year 2012, we had 459. Since 2009, our investigations in this area have resulted in 480 arrests, 336 informations or indictments filed, and 258 convictions. At issue here, and one problem we do have, is dealing with victims who are exploited as a result of human trafficking. We work closely with an Office of Victims Assistance, who, along with victim specialists in the United States Attorney's Office, as well as non-government victim assistance service providers, work with human trafficking victims to advise them of their rights and to ensure that they get help they need to address their short-term and long-term needs, such as legal and recreation service, immigration relief, housing, employment, education, job training, and child care. FBI task forces have encountered significant challenges in identifying and providing services to these victims. Often their histories of poverty, homelessness, and or exposure to violence and abuse result in these victims having difficulty in reaching out for help or actually determining who they can trust. In addition, these victims may need specified resources such as substance abuse treatment, medical treatment for conditions like HIV or AIDS, or mental health services. Many of them face impediments to reuniting with their families of origins, so we need to prepare these victims for help with respect to independent living. As far as prosecuting these cases go, we also do have issues with providing them with transportation, either to their treatment or their law enforcement contact with us when we're investigating cases. or transportation to court or work or things of that nature. Also providing them with life skills and vocational training, getting them new immigration paperwork or social security numbers or a legitimate immigration status in the United States, which is often done by a continued presence status while they're cooperating with us during the investigation. One of the goals that we do have in law enforcement is to provide better training to law enforcement as well as service providers. And we work jointly with a lot of non-government organizations and have a lot of outreach with them as well, because we realize that they provide a significant resource to us when we're addressing victims' needs. Now, I do think it's important to note that there is an initiative with respect to a law enforcement working group that deals with extraterritorial matters. And this initiative is made up of members from the Department of State, the FBI, and Department of Homeland Security. And essentially, they're training United States Embassy staff worldwide. And they're going out globally to train staff to identify potential human trafficking victims during the visa application process. So while someone might be applying for a visa in a foreign country, United States Embassy staff is now being trained on how to spot potential victims. The goal of this training is not only to do that, but also to combine efforts and educate the staff so they can consider the fact that someone who might be filling out a visa that looks suspicious may in fact be a human trafficking victim, and then how to address that in their region within their organization. And typically, we're interested in working side by side with the foreign governments, and we typically do that with MLATs because we do need their cooperation when investigating these cases. As far as what we see here in the United States, the trends that we see with respect to where these cases are coming from, nail salons, restaurant workers, and elder cares are some areas within the United States that we're seeing the uptick on where victims of labor trafficking are. And with that, I'm going to go ahead and pass the baton to Christopher Johnson to follow up on the business model.
Well, thank you very much, Maya, and good afternoon, everyone. I'm going to start with where I was introduced to human trafficking, which was on a mission trip with my church to India, where we had some missions that worked around the red light district. And seeing the enormity and brutality of human trafficking, which I'd only heard a little bit about before then, really struck both myself and my wife to the point where we did want to get involved in this area. Now, of course, upon returning to the United States, I started talking to people, realizing that not only was this a big problem, but there's a big problem in the corporate world with respect to supply chain. And that was the place where I decided to really focus my efforts in this area. And when Laurel Bellows, the immediate past president of the American Bar Association, decided that one of her commitments was to end human trafficking, and she formed an overall task force to engage every area of the ABA in this. I was fortunate enough to join the working group of the business law section, which was charged with developing, at the time we called them business conduct standards, to eradicate forced labor in supply chains, and the name has changed, as you see. And we assembled over 50 leading business experts from in and outside of the ABA, judges, in-house, outside counsel, NGOs. Kelly is a member of our working group, academic, government experts, so that we could really try to address this problem, try to provide corporations with a tool. And I'm going to talk to you a little bit about that tool. We took about 18 months to do this, frequent calls and face-to-face meetings as well. And I went through about 100 drafts of this document before we came up with what what I'm going to discuss with you, and what is now, at least part of it, is ABA policy. So we have, I'm going to tell you about a number of the pieces of this. We have the model principles, and I'll talk about them in more detail in a minute. 4 principles for businesses and 4 principles for suppliers. And then we have model policies, which are an expansion of the principles. They provide an example of how a business can develop a policy based on the model business principles and the supplier policies. Includes an introduction with some background, some of the information you've heard today about human trafficking, and then commentary and guidance regarding each principle, and then a glossary that defines terms. And what we're in the process of now doing is developing a database of resources, because we realize this area is anything but static. The law is changing daily, both at the state and federal level, and we need to be responsive to that and try to maintain communications with those that are interested in working with us on these policies or using the policies to try to stay current with these developments. So let's look at the policies themselves, so the principles, I should say. Very, very straightforward, and the business supplier will prohibit labor trafficking and child labor in its operations. And this is obviously the fundamental commitment of the company or a supplier. These are the same 4 principles, by the way, for both suppliers and companies. And what's expected under this one is that the company will adopt a policy prohibiting the use of labor trafficking and child labor, not knowingly tolerate any labor trafficking and child labor in its operations, and comply with laws regarding labor trafficking and child labor in the country or countries in which the business has operations. So just to show you one of the differences in the supplier policy under this model principle is that, again, still adopting a policy, still not knowingly tolerate, but then the third thing is to certify to the business that the product or service provided to the business complies with the laws regarding labor trafficking and child labor of the country or countries in which the business and supplier have operations relating to the products and services being provided by the supplier to the business. So that's just an example of some of the detail, and there's more under one of these policies. Number 2 has what many of us feel are one of the most important aspects of the model principles and the policies, and that is the risk assessment. The risk assessment is, we think, an important element of the policies because it allows for corporations to ascertain the level of risk that presents itself in their operations, and then to design their remedial efforts appropriately. And we thought that was a very important part of what we were trying to accomplish here. And so to help ensure that measures to address issues of labor trafficking and child labor, they're commensurate with the risk identified. So the sources of the greatest risk obviously receive the most attention, and that facilitates an efficient allocation of resources. Kelly mentioned a number of suppliers, and in some cases even larger than that. So you really have to focus your efforts, especially if you're with a large company that has thousands of suppliers, tens of thousands of suppliers, in some cases hundreds of thousands of suppliers, in order to pick the places that have the biggest risk and then focus your efforts there. You look at for instance, and the factors that are considered here are the type of business being conducted, where the business will be conducted, the history of labor trafficking or child labor in the industry or sector, what is the operating context, what are the products and services involved, and any other factors that the business or supplier deems reasonable. So that is going to help companies really focus their assets. We've talked, I think Kelly mentioned the Department of Labor report that lists goods by country and goods. Well, that's a great resource to look at in terms of, are we producing either those goods from that country, or are we producing in that country, depending on the situation, or are we sourcing from that country, and looking at the actual risk that's involved in that in the given situation. The next principle, the business supplier should train relevant employees, engage in continuous improvement, maintain effective communications. Obviously, very important that the relevant people in the company be trained on what is transpiring, in the world with respect to supply chain, and then what's transpiring in the company, and that a good communications mechanism is set up between the company and its supplier. And then finally, the business and supplier will devise a remediation policy and plan that addresses remediation for labor trafficking and child labor in its operations. If you find a problem, you need to fix it. And again, the business has to consult with its relevant stakeholders and devise a remediation policy that addresses remediation for individual victims where the business itself caused the labor trafficking or child labor, or remediation of broader patterns of noncompliance within the policy. Those are the four general principles, and they're consistent with the UN guiding principles on business and human rights. And I mentioned they adopted the risk-based approach, not prescriptive. And we started out with prescriptive, and that just wouldn't work, wasn't reasonable. So, which is why we went back to a risk-based methodology. Working definitions of labor trafficking and child labor, and then we're really hoping to assist businesses in developing and modifying their own policies, and then substantially compliant with the major laws, the California Transparency Act, and that Kelly mentioned. There's a new federal law, as a matter of fact, that was just introduced by Representative Maloney I think it was last week, H.R. 4842, Business Supply Chain Transparency. Very much like the California law, requires disclosure, but in this case, disclosure to the SEC about actions that are being taken with respect to both labor trafficking and child labor. And our policies and principles deal with both labor trafficking and child labor as well. The executive order and then European Union laws. So try to develop these, again, to be helpful and to remain consistent with the growing body of law and regulation in this area. In the one area, I'm going to talk in a minute about Foreign Corrupt Practices, but there was an emphasis in the recent report on the Foreign Corrupt Practices Act by the Department of Justice and the SEC about the problem of corruption in the world and how what it does to economic growth, and you can see on the slide, it undermines the democratic values, it threatens stability and security, and they mentioned trafficking of people along with weapons and drugs as being among the problems here, and undercutting good governance that impedes our efforts to promote freedom and democracy and poverty. So, a lot of difficulties, in the world of corruption. So let's look now at what a how a situation might present itself. I'm not seeing the slide come up here. Okay. So the FCPA, as you know, it basically prohibits any U.S. person, very broad definition. It's going to include agents corruptly paying or offering to pay or promising to pay anything of value. That can be gifts, it can be gratuities, it can be money, any number of things there. To a foreign official, another very broad definition can include a state-owned enterprise, officials on a state-owned enterprise, in addition to what you typically would consider foreign officials. And then directly or indirectly, I think the report said about 90% of the cases are indirect, not the company doing it themselves, but an agent of the company that does something, and that is what causes the company to get in trouble. And what the act, what you're trying to do is you're influence any act or decision of a foreign official to obtain or retain business or secure an unfair advantage. So how does this work in the within the context of a human trafficking situation? Well, here's a graphic, and basically this is a situation that you see many times, that Malaysia is a receiving country here. Here's a foreign subsidiary or a JV of a partner or supplier of a U.S. company. They're working with a labor broker in Malaysia, and that labor broker is required to basically onboard employees. You have some foreign contract workers from another country. They're working with labor brokers in their company. All the contract workers are paying fees to many of these people. There could be additional people in the country, their home country, and then they could also be paying the Malaysian labor broker. And then there's money that exchanges hands between the sending country labor brokers and the Malaysian labor brokers. Now, this is where the FCPA piece of it comes into. The Malaysian labor broker then has to deal with the Ministry of Home Affairs and the sending company, labor attachés, other governmental entities here in order to bring these people into the country. If they are bringing people into the country and illegally, then they would have to, or they would find a need to perhaps bribe some of these foreign officials in order to facilitate bringing these foreign workers into the country. And of course, that's where you have your FCPA problem with bribing the company officials. The labor broker is an agent. They have a power of attorney from this company, from the foreign subsidiary or supplier of a U.S. company. And I'll show you another slide here that lays this out. So here we have our elements. And taking, you have your foreign sub or supplier as a U.S. person. The corrupt aspect here is trying to get these workers in and offering bribes to government officials, to the foreign officials. In this case, it was the labor and medical officials, immigration officials. Could be any number of different people involved here. And the directly or indirectly through the labor broker. And unfair advantage, you have exploited workers, and if you have exploited workers, that's going to be an unfair advantage with respect to others in the area. So that's how we could have a problem in the FCPA. When you're looking at compliance in the FCPA, you need to have a strong compliance program and policy. So if you have this potential problem, then again, I've on this slide shown where the ABA model principles fall into a lot of the things that people think you should do in the FCPA area: conducting risk assessment, monitor, inspect, train, communicate, and then remediate. All issues that are addressed in the ABA policies. So we have the executive order, and Kelly mentioned this earlier, the zero tolerance policy. Very similar to what we have in the ABA policies. And then the other prohibited conduct are things, trafficking-related activities, these two were mentioned about some of the things, destroying or concealing identifications, which is one of the methods that traffickers use, charging employees recruitment fees. You see, the federal government doesn't even allow that, and in some cases, in other cases, it would have to be reasonable. But that's a problem. And then there are things on there involving housing and the like. And these are there are notification requirements that whenever you have a problem, you have to notify the contracting officer or the agency IG. Again, you have a cooperation issue, not only with the government and human trafficking audits, but you have to protect and interview all employees suspected of being victims or witnesses of prohibited activities before you would send them back home. Let's say those workers that we brought over to Malaysia found out there was a problem, and so you had to do something to remediate that situation. And mandatory flow-down provisions. We don't have mandatory flow-down provisions in the ABA policies. We have optional flow-down provisions. And then the larger contracts that Kelly mentioned, a different compliance plan here, appropriate for the size and complexity. Now, these next few bullets, the procedures for agents and the certification after conducting due diligence, what those essentially are going to require you to do is map your entire supply chain. Again, as I mentioned earlier, that's going to be very difficult. But in order to give that certification, it's going to be very hard to do that without mapping the entire supply chain. And then the contract officer can consider compliance plans if there's a problem. Department of Defense contracts, a little different. Important thing here to notice under the DoD contracts, the strategic plan for the Department of Defense and the IG inspectors demonstrate that the DoD is serious about this and that it's more than check the box, and it would include enforcement during times of war. So, the federal government is very serious about this area. And finally, these are some of the comments that the ABA sent in for this, the ABA section on public contract law, I should say. They weren't approved by the ABA House of Delegates. Go down to the last bullet. It goes back to this issue of risk assessment that we mentioned earlier. And this was, I said it was a cornerstone of the policies of the ABA principles and policies, that we have the risk assessment so that companies wouldn't have to map their entire supply chain. So one of the people, as a matter of fact, Michael Navarre, who worked on these comments, it was also on our committee, and he made the suggestion that they take some of the language from the policies that we put together and suggest to the government that they use that in these new regulations when they do come out. So that is going to be interesting to see how that transpires, and I will now turn it over to Martina Vandenberg.
Thank you so much, Christopher. I'm very happy that Christopher Johnson talked about the links between the Foreign Corrupt Practices Act and human trafficking, because one of the trends that those of us who worked on the FCPA frequently saw was an uptick in prosecutions. And as Agent Winkley described, we are seeing precisely that in the federal government's attention to human trafficking over the years. As many of you know, the Trafficking Victims Protection Act was passed in 2000. And the slide that you have in front of you now indicates that in 2010, there were 103 federal prosecutions with charging of 181 defendants. In 2011, that number had jumped to 125 with 263 defendants charged. Now, it's interesting. These statistics come from the Attorney General's annual report to Congress and an assessment of U.S. government activities in the anti-trafficking field. If you're interested in tracking sort of the U.S. government's progress, the U.S. Attorney General's report is an excellent source for statistics and information about the trends that the federal government is moving on. As in the Foreign Corrupt Practices Act world, the numbers just keep going up. And so, again, looking at the federal government's own publications, such as the Department of State Trafficking in Persons Report for 2013 and 2014. The 2014 report was actually just issued on Friday by Secretary Kerry, and you can find it online on the State Department website. But again, this uptick in cases, 2012 up to 128 cases, and 2013 up to 161 cases. Now, what I should mention is that these cases include forced labor as well as forced prostitution of adults, as well as the commercial sexual exploitation of children. But the federal government seems to be doing, in some cases, sort of big-ticket cases, big-ticket items, looking at much bigger defendants, particularly in the forced labor space. So I'll talk about that in a moment. One of the things that I think is little known about the Trafficking Victims Protection Act, but it's very important for those of us who represent victims pro bono, is that in a criminal case, and Agent Winkley mentioned this, in a criminal case, it's not just that we're looking at long prison terms, including life sentences for the traffickers themselves. And recently, by the way, we got a life sentence plus 20 years in a forced labor case here in the United States. The other issue is that there is obviously forfeiture of assets used in the crime, and the federal government does forfeit assets frequently. But from the perspective of someone like me who focuses on representation of victims in these cases, what's important for us is that restitution under the Trafficking Victims Protection Reauthorization Act, based on the amendments to the 2000 Act, restitution is mandatory. So there's not just seizure of assets from the criminal activity, there's also a disgorgement of assets, and those assets should go directly to the victims. Oh, thank you. And while we have this slight pause, I just want to pause for a second to answer a question that's come in from Dan Francis. And the question is, are there any whistleblowing provisions to encourage the average citizen to turn in this activity? Please do send questions in. We are watching your questions, and we love getting questions. In answer to this question, it's very interesting. What we have seen in the whistleblowing space is actually activity under the False Claims Act, which, as many of you know, is a law that was passed in the Civil War era to stop fraud in contracting with the government. And we have seen some whistleblowers bring cases, qui-tam cases, that are, of course, under seal at the beginning, but bring qui-tam cases, particularly in U.S. government contracts context, where one of the allegations is human trafficking. So the whistleblower provisions in the False Claims Act cases certainly adhere. We don't have in the Trafficking Victims Protection Act a separate whistleblower section. But maybe that will come. There are about 19 pieces of legislation pending right now on the Hill. Now, one of the things I think that is also little known, other than the mandatory restitution for victims, one of the other features of the Trafficking Victims Protection Act as amended, and that as amended piece is important because the Trafficking Victims Protection Act was amended in 2003, amended in 2005, amended in 2008, and then again amended in 2013, and I anticipate, based on the last piece of legislation, it will likely be amended again in 2018. In 2003, Congress threw the doors of the federal courthouses wide open to victims of human trafficking. So while many potential federal litigants are being kicked out of the queue and not allowed to litigate anymore in federal court with jurisdiction being stripped, trafficking victims are really quite unique in that the doors are wide open to them. The law is 18 U.S.C. 1595, and it's a kind of oddball provision in Chapter 77 of Title 18, which is the trafficking provisions of the U.S. Federal Criminal Code. It's a little civil remedy lurking among all of the Chapter 77 trafficking crimes. And it's very important because it allows a victim of human trafficking to bring a case against the perpetrator. And as the law has been amended, that case now actually can include as defendants anyone who knowingly benefits financially or by receiving anything of value from participation in the venture, where the person should have known included a violation of Chapter 77, so included a violation of human trafficking law under the Criminal Code of the United States. The reason that little parenthetical is so important is because in the past, when we litigating trafficking cases in the federal courts wanted to bring cases against co-conspirators or co-employers or co-conspirators who perhaps hadn't been indicted in a parallel criminal case, we had to use RICO. And for those of you who are RICO litigators, you know that that's a pretty high standard. It's a pretty high bar. The defendants can demand a bill of particulars. It's a very high pleading standard. This section, although it doesn't have the treble damages that we love in RICO, this section nevertheless makes it possible to go after co-conspirators that normally would have required RICO pleadings. Now, the other thing I want to say about this is in Section A, the law says that you may recover damages. That's a very important piece, and we've had litigation over, in multiple circuits now, over what that means. It's not very specific, but the courts are now uniformly stating at the circuit court level, at the courts of appeals, that may recover damages includes punitive damages. So we're seeing significant damage awards in cases that actually are brought as civil trafficking cases. The only other thing I want to point out, you can read this at your leisure, but the only other piece of this I want to point out is Section 1595C, which is the statute of limitations. You know, in a RICO case, it's a 4-year statute of limitations. In a Fair Labor Standards Act case, under the best of circumstances, it's a three-year statute of limitations. Congress realized that trafficking victims are frequently very traumatized and often very reluctant to bring cases. And so the statute of limitations for these victims is actually 10 years. Now, there has not been exactly a rush to the courthouse to file these federal civil cases. So in the past 11 years, what we have seen is 123 federal cases filed under 18 U.S.C. 1595. But that number is growing by leaps and bounds. Similarly, as we see federal prosecutions steadily marching forward and the larger numbers coming each year, that number has grown by at least 50 in the last year. So when we did these statistics at the end of 2012, for example, our numbers were closer to 70 or 75. So the number is increasing exponentially. The other piece of this that's very interesting is that Congress amended the law so that there is extraterritorial jurisdiction. Agent Winkley mentioned this briefly, but there's actually extraterritorial jurisdiction for many of these cases, and cases are now being federally litigated on conduct that occurred abroad that is brought into the jurisdiction of the U.S. court under part of Chapter 77. So the specific code number is 18 U.S.C. 1596, which is nearly as broad, actually, as the Foreign Corrupt Practices Act. And then there's a second provision, 18 U.S.C. 3271, 3272, which brings under the auspices of the U.S. courts for jurisdictional purposes any trafficking conduct in violation of Chapter 77 that is conducted by a U.S. Government employee, any dependent of a U.S. government employee, a U.S. government contractor, or any dependent of a U.S. government contractor. So these cases are, in a sense, the test cases, the new frontier for where the federal government may actually go in increasing the jurisdictional reach of the Trafficking Victims Protection Act. What's interesting, I think, is the breakdown of these cases, because if you look at the specific breakdown of federal trafficking cases that are brought by U.S. attorneys' offices and by the Department of Justice Human Trafficking Prosecution Unit, which is the unit of subject matter experts within the Department of Justice, there are more sex trafficking cases at the federal level than labor cases when you look at the criminal statistics. But when you look at the civil cases that are being brought by victims of trafficking, that pyramid is completely flipped upside down. And so of the 123 civil cases that we have seen brought in the United States, only 8 of those cases are sex trafficking cases. Another 115, or 94% of those cases, are forced labor cases. Now, we created this pie chart because one of the things that the Human Trafficking Pro Bono Legal Center does is track all of the federal civil litigation in the United States, and we actually have a database of every single case filed. We did manage to sort of get rid of the ones that are somewhat ludicrous, that are nuisance suits, so we eliminated the nuisance suits. But looking just at the core cases that have been brought, 115 of them, again, are forced labor cases, and some of them are actually large cases with multiple plaintiffs, sometimes hundreds of plaintiffs, and they are suing labor brokers, labor contractors, and also end employers who have benefited financially. So I want to talk a little bit about the use of RICO. I did talk about this a little bit in the context of civil cases and the fact that we no longer have to use RICO. But I think it's also important to talk about the way the federal government is prosecuting these cases, because Congress made trafficking a predicate act. And so now that trafficking is a predicate act, and forced labor is a predicate act, and fraud in foreign labor contracting is also a predicate act, we are seeing cases being brought by the federal government that are large and pretty remarkable. The first case I want to talk about is a case called U.S. versus Asghar Khojayev. Mr. Asghar Khojayev was an Uzbek national who came to the United States. He created essentially a conspiracy together with partners from Uzbekistan, from Moldova, and also from the United States. And he brought workers over, many of them from Jamaica, the Dominican Republic, the Philippines, brought them to the United States, recruited them with false promises about wonderful legal jobs that they would have in the United States. When those workers arrived in the United States, and by the way, there were hundreds of them, they were not placed in the work unit that had been used to obtain their visa. So immediately they were placed in an alternative environment to work in, which put them immediately out of status. So their vulnerability, as Mia Winkley noted, their vulnerability was high because their immigration status was now no longer legal. And the U.S. attorney in the Western District of Missouri, the U.S. attorney in Kansas City, brought a case against multiple defendants for what he called a multinational racketeering and forced labor enterprise. The case was brought in 2010. It was the first time that forced labor was actually used as the predicate act in a RICO case. And the scheme essentially ended with workers being sent to 14 states in the United States, forced to work in hotels, paid practically nothing, forced to essentially hot bunk, live like sardines in apartments for which they were charged exorbitant rents. And the workers were held in a form of debt bondage. Now, many of the defendants pled guilty. There was a $172,000 restitution order that was entered against Mr. Asghar Khojayev that he had to pay, but also a $500,000 order that was that all of the co-conspirators were ordered to pay because of failure to pay the IRS. So there was a bill from the IRS under this RICO scheme for about $500,000. One of the materials that you have in the corner of your screen is the indictment in the Asghar Khojayev case, which is about 90 pages long. And what's interesting about the indictment is that the indictment includes, in one of the predicate acts, includes a list of the ultimate employers of the workers who were brokered by Mr. Asghar Khojayev and his global labor organization that he created, the company of the labor brokering company he created. And what you will find, I think, in that indictment under the mail fraud provision, there's an entire table of the end employers. And I think when you actually go through that entire table of the end employers, you will be quite surprised, because the hotels where these individuals were forced ultimately to work by Mr. Asghar Khojayev and his compatriots are hotels that you have stayed in. They are lovely hotels. They are multiple-star hotels. And The reason that they're listed in the indictment is not because they are indicted, but because they issued checks to Mr. Asghal-Hojayev, which he then used the mails to cash. And so part of the indictment lists all of these companies. This goes exactly to the reputational harm that Kelly Heinrich was mentioning. I think there's no company that would like to see its name mentioned in a forced labor indictment, even in the context of not being a defendant. The other case that's a little bit more recent, which is very interesting, is another RICO case, and the case is U.S. versus Batsvunyuk. And Mr. Batsvunyuk was a Ukrainian national. He's the one actually who was sentenced to life plus 20 years in prison. This was a conspiracy between Mr. Batsvunyuk and his brothers, who all came to the United States from Ukraine. They worked in the United States on this scheme from 2000 to 2007 and brought workers from Ukraine. They were promised $500 a month. They were promised room and board. They were promised transportation. They were promised legal immigration status. What we see in a lot of the cases here in the United States is workers promised legal immigration status, workers brought in on legal visas, who then, when they arrived, discovered that the entire situation is not what they had been told to expect. What's interesting about this case is that the brothers, the Batsvunyuk brothers, didn't actually obtain legal visas. Instead, they obtained tourist visas to Mexico and sent the Ukrainians to Mexico and then tried to smuggle them across the border from Mexico. Some of them made it across. Some of them did not make it across. Those who made it across were immediately sent to Philadelphia. Those who were held in detention for some period were also sent to Philadelphia after they were released. Once they got to Philadelphia, that's when the real horror began. They were faced with threats. Two of the women who were held were testified at trial that they had been brutally raped by one of the brothers on multiple occasions. Again, when we think of supply chains, we frequently think of supply chains as something over there. We think of it as a supply chain in Malaysia, or we think of it as a supply chain in Vietnam. What I really want to convey today is that the supply chain also includes labor, and it also includes service, people providing services, and those services are also being provided here in the United States. And I think what will be, somewhat surprising is that the scheme that the Batsvunyuk brothers conceived of, those workers from Ukraine were cleaning large stores at night. So the cleaning crews that come through office buildings, the cleaning crews that come through stores, I think some of us working at 8 o'clock or 9 o'clock at night when the cleaning crews come through, some of us have wondered whether those people are being treated fairly. This case, I think, is proof positive that some of them are not. Those Ukrainian cleaning crews were actually cleaning Walmarts and Targets at night. Again, in terms of reputational damage, if you look at the press release from the Department of Justice, it also mentions that that the workers were cleaning these particular stores. Now, the stores had clearly contracted with the Batsvunyuk brothers, but these are the kinds of supply chains that are ultimately quite risky. The other point I want to make about this, and Agent Mia Weekly, I think, also alluded to this, is just as we've seen in the Foreign Corrupt Practices Act space, we are now seeing more and more in the trafficking space the rise of the MLAT, so the rise of mutual legal assistance between countries. Now, this is no accident because under the Palermo Protocol, which is the international treaty that governs prosecution and countries' policies on human trafficking, and the United States actually signed the Palermo Protocol. Under the Palermo Protocol, which is a UN treaty, one of the requirements is that countries cooperate and collaborate in order to thwart trafficking conspiracies and trafficking criminal activity. And we are finally seeing that. So in the press release that was released by the United States Attorney's Office for the Eastern District of Pennsylvania, the unit that actually prosecuted the Batsvunyuk brothers, the list of the parties who cooperated in the investigation is quite remarkable. It includes the Toronto Police Department, the German National Police, the Berlin State Police, and the Ukrainian Security Service. So we have, also Interpol is on the list. So we have, I think, really unprecedented cooperation now between the law enforcement agencies of many countries around the world. I think we, as Kelly Heinrich noted in the beginning, I think we are very used to thinking about, because of the way it's covered in the U.S. press, we are very used to thinking about trafficking as just into the sex industry. But actually we need to start having a different picture in our mind, a different image. It's not just a brothel. It's not just children walking on the streets in the red light district in Mumbai. It's actually trafficking that's taking place literally sort of right under our noses. The Department of Homeland Security has a new public service announcement that they have just issued. You may have seen it in the Amtrak station. You may have seen it on television. But that PSA essentially makes the point that trafficking victims are right under our noses. Trafficking victims may be in hotels. They may be the women making the bed. They may be the people doing the landscaping. Trafficking is occurring in places that I think we have not expected to find it. In one interesting case, there was a case in Boca Raton, Florida, in a country club. Again, people don't generally associate country clubs with forced labor, and yet 39 Filipino workers were being held in forced labor in those local country clubs. So it's time to start thinking very differently about trafficking. And as I see it, the risk now of criminal prosecution is definitely increasing, just as it was consistently increasing in the Foreign Corrupt Practices Act sphere. But interestingly enough, because there is a growing bar of largely pro bono attorneys who are handling trafficking cases in the civil context and doing civil litigation on behalf of trafficking victims, I think there's an increasing risk for civil cases to be brought against perpetrators and co-conspirators as well. So one of the questions that's come in is from Nikisha Cheney. Can you seek restitution under Section 1593 in a civil case, or is it in addition to the remedy available under the 1595? And one of the cases on the slide that you have in front of you is an example of how 1593, the criminal restitution section, is sort of interoperable or works together with 1595, the civil remedy section. So in the Pena Canal versus De La Rose Dan case, which is the very bottom of the graph that you have on your slide, it's a case that actually had gone criminal, and the government had managed to collect back wages under 18 U.S.C. 1593. So there was actually criminal restitution that was awarded in the criminal case at the federal level. That amount was subtracted from the 1595 damages. So you don't actually double collect. The beauty of the criminal restitution remedy is that happily the government collects it for you. So the federal government is required to collect it, and also criminal restitution collected under 1593 is tax-free. So 1593 is basically the most basic of damages, the kind of out-of-pocket damages that a victim might suffer. And as you can see on this slide, the remaining damages, including damages for emotional distress, punitive damages, compensatory damages, various contract damages, these can run into the millions of dollars. One case involving a diplomat here in Washington, D.C., was a $1 million judgment. In another case where a victim was held for 4 months, there was a $3.3 million judgment in the Eastern District of Virginia. One of the questions that has come in is how to get involved if you want to do pro bono representation of trafficking victims. And the Human Trafficking Pro Bono Legal Center essentially works as a bridge between non-governmental organizations seeking legal representation for their clients and pro bono attorneys seeking to work with trafficking survivors. So as I've mentioned, we do see a real need for representation of victims in criminal cases. One of the things that we're seeing, at least in the sex trafficking space, is vacatur of convictions on the record for people who've been trafficked. There are a number, as I mentioned, of pro bono attorneys doing civil litigation for trafficking victims. We are also looking for assistance in enforcement, both of criminal restitution orders and also civil judgments. And then there are tax questions that trafficking survivors have to face. So I'm going to leave it at that because we've gotten a lot of really good questions that have come in. So let me go through this real quick and ask a couple of the questions that have come in. One question that came in was to Christopher, asking about when the American Bar Association started the effort to create all of the materials that Chris talked about. Chris, could you address that? How long this has been in action?
We started back in the fall of 2012 with this effort, and we started with framing. Then we moved from the framing of the issues and deciding what we're going to cover to the drafting, and that went through all of 2013, and we then submitted it in November of 2013 to the House of Delegates, and the House of Delegates at the mid-year meeting adopted two resolutions with respect to the principles and policies. Number one, the American Bar Association adopted the principles themselves, and then they adopted a second resolution to urge businesses to adopt policies that are consistent with the principles. So that just happened in February, and now we're in the situation of developing materials to send out to various corporations and others to see what if they have interest in in using these policies as guidelines. And we're also going to post them on a number of places in the ABA website and perhaps other websites as well, because we had a number of different co-sponsors within the ABA. And yeah, I should mention that at the House of Delegates, which is about 540 members, the resolution passed without objection of any kind, and so that's basically where we are now. So we started back in the fall of 2012.
That's great. One other question that has come in for Kirill Boychenko, from Kirill Boychenko, is whether there are any examples of Foreign Corrupt Practices Act cases being wrapped up in slavery cases, or whether you've seen sort of any real-life uses of the FCPA and the sort of link with corruption. Kelly, I don't know if you want to address that. I know you're sort of dealing with companies. Have you seen this sort of this operate in criminal prosecutions or in investigations in the past?
You know, I have not. I think perhaps Chris had alluded to some examples in his presentation.
Chris, do you want to take that one?
I haven't seen any specific. These are examples that I used, but I haven't seen any specific cases yet.
Yeah, I think that's true. I think this is new. We have a question from David Frank. Can a claim be brought before there's an investigation? And I think I'll take that one because the answer is yes. The civil remedy under the Trafficking Victims Protection Act is really a beautiful piece of law, because what it means is that a trafficking survivor can bring a case whether or not there's an investigation and whether or not there is a federal criminal case. The other sort of fail-safe mechanism that Congress introduced into 1595, the civil remedy, is that if you look at Section B of the law, Congress created a mandatory stay. So Congress was concerned that civil litigation might actually get in the way of criminal prosecutions, and of course the federal government's priority is criminal prosecutions. And so if there's a civil case that has been filed and the federal government wants to shut the civil case down in order to avoid the danger of inconsistent statements and discovery, huge numbers of depositions and that sort of thing, then the Department of Justice can come in and ask for a stay, and it's practically as automatic as a bankruptcy stay. And so the government can request it, and courts will provide that. So the criminal case will proceed to its final verdict, and then the civil case can be sort of awakened like Sleeping Beauty and can continue. We have a question from April Van Voorst Meek. which is how do you go about assisting a victim of human trafficking who's afraid to leave? How do you handle a case where you know someone has been trafficked, but they're actually afraid to get out of the situation? Mia, I don't know if you can answer that. If you have dealt with situations of trafficking victims who've been too frightened to exit the situation.
Sure. I will say, and not to be crass, but it does take a village, not just the investigators coming forward with some kind of rescue plan, but we do rely heavily on non-government organizations and advocacy groups, because I do find the fear has to deal with what's going to happen to me now. Am I in trouble? Things of that nature. So as best as I can when I'm dealing with these cases, I try to have those resources at the ready when we approach a victim, so they have a clearer understanding of there'll be a place for them to sleep tonight, tomorrow, the next day. Someone's going to speak their language. They will be taken care of. And, after they get a little settled is when I might talk to them about the nature of the crime and potentially their involvement or cooperation in the case. But ultimately, if they do not want to cooperate, I work with the NGOs or their attorneys or a psychologist and get feedback as to whether or not it's healthy for that person to proceed with the case.
Kelly, I know you've worked with a lot of trafficking survivors as well. Do you have thoughts about how to help someone who's too afraid to depart, too afraid to get away?
I do. Well, the first thing I think is important to share is if you're coming across someone who's still in the trafficking situation, you're going to feel torn. You're going to want to help them immediately and get them out of the situation. But you may also not be aware of whether or not your own safety is at risk as well. So as Mia was saying, the more you can engage, experienced law enforcement or NGOs in your area, the better. There's a national human trafficking hotline number. Anyone can reach out there, and they can do direct referrals to both law enforcement and those NGO service providers in your area. So that's my number one tip. But when I was providing legal services to victims years back, I had a number of situations where there would be a concerned neighbor or someone who wanted to report a suspicion of something that they had seen, for instance, going on across the street or at a business nearby their home. And those were the steps that we even took as service providers. We had very good working relationships with law enforcement who could either begin a quiet investigation to get the person out, or there were times where, it was that concerned citizen or neighbor who was able to slip a phone number to the person and at least start telling them, there is help available. I know that you're being threatened or told that there may be immigration consequences, but there's help, there's people that can talk to you, there's people that can provide social services, legal services. You can imagine when you're in such an extreme and dire circumstance, you can start to feel very, very alone. And, of course, completely believe and trust in everything that the trafficker's telling you. So even just letting them know that there is help available can be a big thing to break down those barriers. And then the service providers, once they have the basic needs met of, their personal safety, shelter, food, reconnecting with their family back home, then you can start to have really the mental space to even entertain the idea of continuing to work with law enforcement from that point forward. So, just echoing what Mia was saying, working with those NGO service providers and law enforcement is key.
So just for the record, the phone number for the National Human Trafficking Resource Center is 888-3737-888. And I would just echo particularly what Agent Mia Winkley said. You don't actually know what's going on behind the scenes, so you need to let people settle down. Just looking at the press release from the Butzfunik case, some of the workers who ran away, their families were then threatened and extorted back in Ukraine, and the families were threatened with mutilation, with rape, and with death. if the workers did not repay their debts, and those debts range between $10,000 and $50,000. So you can understand why a worker might be terrified to come forward if they know that their family members back at home are in real danger if they cooperate with federal or local authorities. So changing gears just a little bit, we have a question from Rich Riddle who says, banking has the OFAC list to prevent doing business with specific persons and entities who may be terrorists. Does labor have an equivalent list for general distribution? Christopher, do you want to take that case? Are there, in the ABA process, did you come across sort of useful lists that you could use?
Well, the Department of Labor list that was mentioned is the one that's produced by the government that identifies by country and by type of good products that are made with a significant incidence of forced and or child labor, and that's a very comprehensive list. I think the last one of the lists came out very recently, and so that's one list that's out there. There's a Trafficking in Persons report as well, which just came out last week, and it too, it's not as product directed as the Department of Labor list, but it too describes issues within certain countries. So if you're looking at a country and you wanted to see what the environment was like in that country with respect to human trafficking, that would be the other governmental list that is mentioned. And there are some private entities as well that have various lists, and there's a Good Guide website, Work to Live website. There are a number of other websites that are developed by NGOs that also have lists of products or lists where you can ascertain the social conduct of the producer of a particular product. Many times those lists have trafficking issues as well as other human rights type issues incorporated into their rankings.
I would just add that there's a wonderful organization called Verite, and Verite operates out of the United States, but Verite actually does supply chain audits, and they are recently, when Secretary Kerry announced the U.S. government's increased focus on supply chains, the State Department announced a partnership with Verite. So you could check out the Verite website. There's another website that's funded by Humanity United that's called Know the Chain, so that companies are rated on whether or not they have posted a policy about supply chain transparency and whether or not there is a actual scrutiny of their own supply chain. So there's a lot of work being done in this area, and there's also a lot of work being done in terms of investigations that are being prepared and civil complaints that are being prepared around the United States. We have a bunch of. Go ahead, Chris. Did you want to add?
Yeah, I just wanted to add. You mentioned Verite, and I'm glad you did, because that very neat slide that I had in there with the graphic came from Verite. As a matter of fact, I spoke with them at a conference, and I really like that slide because I think it really graphically displays how easy it is to get into FCPA difficulty in this area. So I thank them for that.
So we have another question about civil cases, and Joel Welty writes that he's handling a civil case on behalf of a forced labor victim, but in state court. And asks if there's any advantage to involving local or federal law enforcement. I can take that one very briefly. A lot of the pro bono attorneys handling these cases prefer to be in state court, and particularly in California, because the law is so good in California and because you don't need a unanimous jury in California. So it's not absolutely necessary to go into federal court, and many of the states are now passing private rights of action for state causes of action for trafficking and for forced labor. The only piece where it may actually be required to involve local or federal law enforcement is actually where your client is a foreign-born victim who needs some sort of immigration relief. So I think it's nearly really time for us to wrap up. I think we just have a couple more minutes. I don't know if Chris or Kelly or Agent Winkley, if there's any sort of final comment that you'd like to make just to close us out. Chris, do you want to start?
Yeah, I would just say that what I'm seeing is increased levels of enforcement and interest by the federal government, by the National Association of Attorneys General in this area. So I think the scrutiny is going to only get more significant. I mentioned the new federal law that was proposed that just last week, and so there's going to be more regulation. And one of the things we were trying to do at the ABA was provide a tool to companies, and certainly Kelly's organization, Verite, all of these are wonderful organizations, and we're just another entity that wants to help corporations in particular develop policies and practices that will help them in this area and help free some slaves.
Agent Winkley, Mia, do you want to add anything to that about the work of the FBI?
Sure. I just want to impress upon everybody that, you know, we do really try to seek inroads in the community. So, you know, join an advocacy group, make a phone call, let people know you're interested in helping out or providing information regarding trafficking or your suspicions or theories or things of that nature, because we do look at this as a joint effort with community members as well as law enforcement and international community law enforcement members as well.
And Kelly, do you have a couple seconds? Do you want to add anything?
Mm-hmm. Well, I'll just reiterate what I had closed with earlier, which is the anti-trafficking work does not have to be something that's completely standalone. It can be woven into a lot of existing initiatives, policies, and efforts. Chris gave a brilliant example with the FCPA work of how you can incorporate it into that.
And I'll just close out by saying there have been a lot of questions about how to get involved in pro bono trafficking work, and I would send you to our website, which is www.htprobono.org, and you're welcome to contact me if you're interested in getting engaged in pro bono work with trafficking victims. So I'm going to hand the baton back to Kathleen. Thank you, everyone, for participating.
Thank you so much, and many thanks to Kelly, Mia, Chris, and Martina for an outstanding presentation today on such an important topic. We encourage today's attendees to please complete the survey that will appear for you at the end of the webinar. It really helps us shape programs that meet your needs. We would also encourage you to continue today's conversation at Lex Talk, which will begin at 3:40 Eastern Time, and in that forum we will attempt to address any questions that may not have been answered during today's webinar. Thank you all again, and have a great day.